You don't do water rights in a vacuum. It includes everything that is our history. It gets integrated into the process. Some of the general framework that most tribes in the West will have to consider has to do with the prior appropriation water rights system that generally exists in the West. Generally speaking, prior appropriation, the common phrase used is first in time, first in right. And it comes historically from the systems that were created in the gold mining camps. The concept of diverting water, bringing it from point A to point B. The concept of claims, especially in places like the state of Montana, were brought forward because in the state of Montana, their system requires that individuals had to have filed a water rights claim. What developed was a system of priorities. So prior appropriation based on the system of priorities, in that on any given stream, the first person that comes to use the water on the stream has the first priority, and second and third and so on. And what that means generally in Western water law today is that on any given stream, as the water dries up, say throughout a season, the last person to get water is the person with the first priority. So if you're 10th in order, as the stream drives up, the other people who have earlier priority dates can ask you to stop using water. There are a lot of other features to the prior appropriation system. You can lose the water if you don't use it, as an example. And that's all in distinction to the reserved water rights. The prior appropriation systems are generally codified in state law and changed over time. The reserved water rights concept comes strictly out of the federal courts. In particular, the Winters rights, beginning with the Winters rights in 1908, came off of the Fort Belknap Reservation in Montana. And ultimately, the United States Supreme Court decided that the water was reserved for the purposes of the reservation. The purpose of the reservation, generally speaking, is to create a homeland for the people who would reside there. And you go back to the treaties or executive orders or the establishing documents that establish the reservations in the first place, begins to help you understand the purpose of that particular reservation, but also begins to demonstrate the importance of understanding the history of any particular tribe or tribal government, because it all ties eventually in defining what tribal water rights are. The Supreme Court said that when the reservation was created, they had to have the water to go with it in order to make it viable for them as a homeland, to be able to irrigate, to have water for drinking or stock water or whatever purpose they were putting the water to use. Over time, the question has become how much and how do we decide how to quantify that. The state of Montana created a new constitution in 1973. The constitution said the state had to create a system of organizing their water rights in the state. So they passed the Montana Water Use Act and then amended that in 1979. It basically said that every individual water user in the state had to file a claim for their water use, for any water use that existed prior to July of 1973. The 1979 amendments to the Montana Water Use Act also established the Montana Reserved Water Rights Compact Commission. And that was at least tacit recognition of the fact that there are reserved water rights. And the purpose of the Reserved Water Rights Compact Commission was to negotiate with tribal governments and federal agencies who had reserved water rights in the state of Montana. As soon as the state enacted the law that said everyone had to file a claim for the pre-1973 water uses, That law included all tribes in the state. And the United States and all the tribes joined and filed immediately 7 lawsuits in federal court because the United States and the tribes believed that reserved water rights were created by federal law, and so it was a federal issue, not a state issue. That case went to United States Supreme Court. And the United States Supreme Court came out and said that states can adjudicate tribal reserved and federal reserve water rights under state law, but that they had to follow federal law. Consequently, the tribes in that process will have their water rights adjudicated by the state. And the state of Montana had set up the system to either file your claims and adjudicate your water rights in the Montana Water Court or negotiate them. Most tribes and the federal agencies have negotiated water rights with the state of Montana and have not adjudicated those rights or litigated those rights in the Montana Water Court. The state set up the Reserve Water Rights Compact Commission, and it's the only state in the nation that has set up such a compact commission to negotiate water rights. There are 3 parties at the table. So where in other states' negotiations you might end up with 6 or 8 or 10 or 100 other parties at the table or more, here there are 3. The parties are the tribal government, state government, and the United States. And in the process, the 3 parties come together and talk about legal issues, talk about technical issues, and ultimately try to put together a settlement that the politicians can agree to. The settlement has to be approved, and it'll be approved by Tribal Council as a decision maker for the CSNKT, by the Montana Legislature as decision maker for the state of Montana, and ultimately by Congress. Once it's gone through those approvals, the compact then comes back to the Montana Water Court, and the Montana Water Court for our region of the state then has to put that compact into a final decree that will decree everyone's water rights here on the reservation and within our area of the state. We do some technical analysis, beginning with the hydrologic analysis. How much water is there? So for many years we've been studying that on the reservation. We have certain treaty rights that we're trying to protect, and that includes the right to fish and hunt and gather. So in-stream flows for fisheries are important to us. CSKT, like other tribes, have the right to past, present, and future water uses as part of their claim. So in that, we will document all of our historic uses, all of our cultural uses, and all of our present uses. And we also anticipate all of our future uses, including potential commercial uses, domestic uses, municipal uses, and industrial uses. That's being put together with some of the legal concepts, such as the reserved water rights, aboriginal water rights. So while the reservation was created in 1855, the tribal people and tribal government has been here for thousands of years. And if you go to the concept of the priority dates in the prior appropriation systems, our priority date would be the date of the creation of the reservation, 1855. Aboriginal rights, the courts have said that priority date is time immemorial. It is so long ago you can't put a date on it. There are 7 reservations in the state of Montana, and then there's the Turtle Mountain Tribe's allotments in the state of Montana, right? So of the 7 reservations, the state of Montana has negotiated with 6, and they've yet to deal with the Turtle Mountain allotments. There are a few tribes that have litigated. Most tribes have tried to negotiate their settlements, and there are today 19 or 20 tribes in the United States who have settlements. There are another 20 or so tribes that are in line to negotiate settlements, and others who haven't even begun. There is some relationship between water quality and water quantity, which is the water rights, in that Generally speaking, you are going to want a water right that is also useful. It doesn't make sense to have a quantity of water that if it's for domestic supply that you can't drink. It doesn't make sense to have water that is for in-stream flows for fish that is polluted and the fish can't survive in. We can and probably will build some language into the law we create that will recognize the importance of water quality. There are differences in tribes. No two tribes are the same. Their history and their culture will influence how they think and how they negotiate their water rights. What's important to them will be an integral part of how they negotiate or litigate their water rights. They will make their decision about the importance of that based on their history, their culture, their technical ability, their legal ability, and their politics. This process is meant to define another way of showing how we define sovereignty for ourselves. Fundamentally, a lot of this has to do with sovereignty. What keeps us going is this is our place. This is our homeland. This is for forever. And we'll only have one shot at trying to protect this resource into the future. And so we've got to do the very best we can. We've been here 10,000 years and we're not going anywhere. So there's no reason not to do it right the first time, because if we won't get a second shot at this. This is about our ancestors, this is about our people today, and this is about future generations. And this is about our place, this place, what little bit we have left. And that's our homeland, and that's what we look to, is how do we protect and preserve these resources in this place, and how do we manage it for not only for ourselves but for future generations. So that's what's important about it, and that's what keeps us going.